Good morning, stakeholders. Morning, share. Before we proceed, I just want to make sure that you can hear. Please give me a thumbs up if you can hear my voice. Thank you so much. Good morning, everyone, and welcome to today's informative webinar. My name is Naledi Mphahlele. Some of you might know me on email. I'm the Stakeholder Relations for the PPRA. I assist with webinar, workshops, conferencing, corporate events, and other related matters in line with Section 69. I will be assisting Advocate Vile today. We are very thrilled to have you join us today, so we can dive into the important topic of registering timeshare. Today, Advocate will take us through the requirements and the step-by-step processes, so that you are able to know what's required from your side, the fees and the changes that come with the legislation. She's going to give us key insights to ensure a smooth, successful registrations, for yourselves, timeshare. So this session today is very important, for either you are new or you want to become a timeshare in the sector. It will be very relevant, this presentation that will be given today. So I'm not going to take hands. I see a hand. What we're going to do, we're going to allow Advocate Val to give her presentation. Once she's done with the presentation, we will unmute everyone. Then you raise your hand and we will take the questions. Also, you can put your questions on the chat and we will monitor the chats and we will pose those questions to Advocate Vile after she has done with the presentation. Some of you might know Advocate Vile, and some of you, maybe you are hearing from her for the first time because she has taken over recently as acting executive manager for the licensing and exemptions department here at PPRA. And she's also a Fidelity Fund claims manager. Who is Advocate Vile? She obtained her BA Law and postgraduate LLB degree at the University of Natal, and she's been an admitted attorney for 38 years. So she spent more than 20 years as a prosecutor on the criminal and civil magistrate with Department of Justice and 11 years in private advocate practice dealing with all areas of civil law. She's also an expert in litigation, legislative compliance, and civil liabilities because she did act previously as an enforcement acting here at PPRA. So she's now in the licensing and registration business unit. So the way I've mentioned that the questions, we will deal with them once we are done, and I will monitor the chats, and we will share the slides after the meeting. I also emailed Mr. Lee Grayling the presentation so that she can share with you. If you did not receive the presentation, please put your email address on the chat and I will send you the presentation while we are in the proceedings, while Advocate Vile is presenting. We are also going to download the recorder of the webinar, which we will share the link with Mr. Grayling, and we will also put this link on our YouTube channel. Please follow us on YouTube. It's PPRA TV, and also follow us on our all social media. For me, let me not waste any more time. Please join me in welcoming Advocate Deborah Vile. Advocate, over to you. You can unmute and take us through the presentation. Thank you.
Thank you, Naledi. Can I just check if you can hear me and if you can see the presentation? I have put it in slide mode. So are you seeing it correctly?
Yes, we are.
Thank you very much. Good morning, everybody, and welcome. It's very good to have you all with us and to be able to give you an overview of some of the important aspects of the Property Practitioners Act, which will regulate you, as well as the process for registering with the Property Practitioners Regulatory Authority. First thing we will do is look at the 12 categories which the Property Practitioners Regulatory Authority now regulates under the new PPA. You will be aware that the old Estate Agent Affairs Act governed us previously, created the Estate Agency Affairs Board, and that board regulated only estate agents, a few managing agents who dealt only with body corporate matters, and attorney employees who fell under the jurisdiction of the Act. So those were the only industries or sectors which we regulated. We now have 12, and these are they: the estate agent sector, which is with us already, auctioneers, bond and bridging finance originators, HOAs who perform property practitioner activities. That is homeowners associations, for anyone who's not familiar with that abbreviation. Managing agents, property facilitators and intermediaries, business brokers, including sales of franchises and business undertakings, developers who market and sell their own developed property, timeshare and fractional ownership practitioners, property advertising platforms, and property practitioners who specialize in collecting and distributing trust money in terms of Regulation 2.4.1. These we call payment processing agents, and payment processing agents are specifically defined in the regulation as being part of the property practitioner industry. What this means, for those who are not familiar with this, and it may not involve you at all if you don't deal with trust money, but in terms of the Act, all property practitioners are required to hold and keep a trust account, which they must put all trust money into. And such reference refers particularly to business property practitioners. So business property practitioners are the firms that operate a property practitioner business, and they are governed and are the responsible person for them is, of course, their responsible director or directors. So, excuse me, in terms of that requirement, all firms will have to have a trust account in terms of Section 54(1) of the Act, and any of their employees who perform property practitioner activities and are therefore property practitioners must make use of that trust account to place all trust money into the account and keep it there in terms of Section 54(3) until they are lawfully entitled to pay it out. Now, some property practitioners find it difficult to maintain a trust account, do all the accounting and balancing of books and records that is required by the Act in relation to that, as well as manage the audit of the trust account. And so in terms of this particular provision of the regulations, they are permitted to have a payment processing agent operate their trust account on their behalf. And a payment processing agent then has to comply with a large number of auditory issues and ensure that we can properly monitor those trust accounts through the payment processing agent. And then the last one is attorney employees. And attorney employees are those employees specifically who are employed by an attorney in the attorney's legal practice, whose work consists wholly or primarily of property practitioner activities as defined by the PPA. So those attorney employees that are not property practitioners, they don't perform those activities, we do not govern or regulate. We do, however, regulate attorney employees whose work wholly or primarily consists of those activities, and they have to register with us, and they will obtain a registration certificate as opposed to a fidelity fund certificate. And the reason for that is that if there is any loss as a result of their behavior, that is covered by the LPC fidelity fund and not by our fidelity fund. So that's a short overview of who we regulate under the new Act. The Licensing and Registrations Business Unit performs three functions mainly, and registration of all property practitioners in terms of Section 47 of the Act is the most important of those functions. We do that by issuing fidelity fund certificates or registration certificates, and we take appropriate payment. Please note that payments, fees, etc., are designated by the regulations. It's not something that we decide for ourselves. All fees are designated in terms of the regulations, and we charge admin fees for certain services where they are fairly labor intensive, the costs involved require it, and we don't charge a registration or other fee as prescribed for those particular services. We also do renewal of fidelity fund certificates, and you should all be aware that any property practitioner, which would now include you in the definition, must have a fidelity fund certificate in order to operate legally. If you do operate legally, you are entitled to ask or charge remuneration. And if you don't have a fidelity fund certificate, you may not charge remuneration for anything that you do that is a property practitioner activity. And if you receive any money, it has to be repaid on request. So you can see that you cannot work without a fidelity fund certificate, and you can see the importance of that. The other thing that we deal with is exemptions in terms of Section 4 of the PPA. The Act provides in Section 4 that a property practitioner may apply for an exemption from any of the regulations or provisions of the Act, and they do so by submitting an E1 form. The E1 form you will find in the regulations, and we will discuss that a little bit later. Send it to the Section 4 exemptions address. We consider it before it's considered, in fact, by an exemptions committee, and then we issue you with a certificate if the exemption has been granted. The other thing you need to note in relation to FFCs is that the FFCs we issue are valid for 3 calendar years, unless the first year of the 3 years is in fact your first FFC. So an example of that is you decide you are entering the industry now, which you will all be doing. If you register now in September, you will receive a fidelity fund certificate that is valid for 3 years. That is 3 calendar years, and a calendar year runs from the 1st of January to the 31st of December. Now, your normal renewals are done by the 31st of October of the previous year for the following year. So if you are already existing as a property practitioner, when you apply for your renewal before the 31st of October for 2025, you will get a new FFC for 2025, which starts from the 1st of January. However, if you are entering this year, you are registering and you need to have a fidelity fund certificate for this year. So your first year will be this year, and because you are coming in only in September, your FFC becomes valid from September, and it will operate until the end of December of this year, and that will be your first year. Second year will be 2025, and your third year will be 2026. And this is set out in the regulations, and you can have a look at Section 15 of the regulations, and you can look at Section 22, 23 onwards in relation to the provisions about fidelity fund certificates. But most important of all, as referred to in the slide, Section 47 and 48 deals with fidelity fund certificates and the right to operate. All right, a few important aspects that you need to know. With the registration of property practitioners, as with all property practitioners, so that's not only your industry, but all industries, no property practitioner can register or operate unless they are registered as a director or an employee of a registered business property practitioner. That is a property practitioner registered with us. So just to explain that, what it means
Sorry, Advocate.
is that... Yes.
Advocate, you are on slide 4. I'm seeing on the chart and I'm getting calls that they're struggling to see the slides. So I want to make sure that it's moving for everyone to see.
Okay, I'm looking at the one I'm dealing with now. So let me just put it out of slide mode and see if I can see where we are.
On my side, it says slide 4. And Carrie says it's not moving, right, the presentation.
I'm on
they
slide
can
4.
See the slides. Okay, Carrie can see. I'm not sure why they can't see the presentation. The slide is still on slide 1. They're saying it's still on slide 1. Maybe let's close it and let's share again.
Okay. Stop sharing. Okay, it seems to be working now. Is that right?
Yes, yes, they can see. Please give us a thumbs up if you can see the slides. They can see it. We can continue. Thank you, Advocate.
All right, sorry about that. It was showing it for me, but not for anyone else, apparently. Good, okay. So we're at slide 4, important information. I was explaining, I think, the principle of having to register a firm in order to register as an individual. So let me explain that concept. So it may be new to some of you. So if you want to register with the Property Practitioners Regulatory Authority, you need to register under a firm. In terms of the Act, you cannot operate and register only as an individual. Your individual right to operate depends on your registration under a valid firm that has a Fidelity Fund certificate, has a trust account, and has a person who is responsible for that firm and is registered as such. So this is why there always needs to be a firm that is registered with us by its directors. And once that is done, the employees then register afterwards. So as you will see in the first bullet, property practitioner firms and their directors are required to register simultaneously. And when I say directors, we use the term director for all property practitioner firms who are not estate agents. Estate agents have their own set of educational criteria, which allows them to call themselves principals, non-principals, full status agents, or candidates. That is not yet in existence for the non-estate agent property practitioners. So we cannot register you as a principal or a candidate or anything else because you don't fit into that category or that status as it's defined for estate agents. So the result of that is that we register everybody as either a director, and that is whether you're a director or a member or a, what else would it be, a trustee, because we register trusts as well. Your designation with us will be director of the firm. So you're a director in the sense that you direct the operations of the firm. The firm itself will be registered as a business property practitioner. And then any person who works for or is employed by that firm in whatever capacity, if they perform property practitioner activities, must then register under the firm as an employee. All right, all persons who register and operate a property practitioner firm, as I've indicated, are designated as directors. These company directors must be reflected on the SIPC documents. So those will be submitted to us, as you will see, along with your application form. And you have to, as a director of that firm, you have to be indicated as such on the SIPC documents that you submit to us. CC, same thing. Trustees, same things. But of course, we refer to you also as a director of the firm. There is a proviso which needs to be considered in relation to this, and this is Regulation 4117. So this will apply unless Regulation 4117 provides certain of your directors, members, or trustees with an exemption from that. So if we look at Regulation 4117, you will see that it says where a property practitioner that is a business property practitioner has non-executive directors, finance, marketing, IT, or HR directors, or any other director who is not directly concerned with the management and oversight of individual property practitioners, exemption should be ordinarily granted from the provisions of Section 48(1) and B and 48(2), in respect of such persons upon application being made to the authority. So what this means basically is that all directors must register with us unless they fall into this category, in which case they must still register with us unless they have submitted and been granted an exemption on the basis that they are one of these directors. Okay, this is to ensure that people who are not involved in the day-to-day operations of the firm, don't have anything to do with property, maybe they're stationed overseas, maybe they only do an oversight provision role in relation to finance or HR, don't need then to have a Fidelity Fund certificate. So that is an important aspect to remember. Right, let's go back. Okay, once again, this is not moving, so I'm just going to try. There we go. All right. Further important information is information on exemptions. I mentioned this earlier. And section 4 is the section which allows an exemption to be granted for a maximum of 3 years and not retrospectively. So that means that you can apply going forward, but you cannot apply to be exempted from something which happened prior to the exemption being granted. In order to do that, we use section 4 exemptions at the ppra.org.za, which is the section 4 exemption email address. And please note that it will not, your exemption will not get attention if you send it to exemptions at the ppra.org.za. This is a different department. It's a different type of exemption. It's an exemption that has existed long before the section 4 exemption. And that one relates to equivalency exemptions, which is an education exemption that is set out in Regulation 33. So what Regulation 33 says is that if you have to obtain a certain standard of training or a certain qualification, but you have another qualification which may qualify you to do the same thing, you can apply for what is called an equivalency exemption instead of having to do the exemption that is the qualification that is prescribed. So that relates to education. So please do not use exemptions at the PPRA. Please use section 4 exemptions at the ppra.org.za. You submit an E1 form. You will find that under Regulation 41.21 in the regulations. You submit it with a motivation. There is a committee that will consider it, and we will issue you with a certificate. You have to state in your E1 form what section you want to be exempted from, why you want to be exempted. Then you need to provide us with whatever motivation or evidence that supports your application that you want to attach. I've mentioned trust exemptions. Trust exemptions are set out in Regulation 2. So if you want to have a look at that, you will see under what circumstances you can be exempted from having a trust account, and you obtain a trust account exemption in a different way. Please do not use an E1 form for a trust account exemption. The regulations provide a different format, and that is an affidavit, which is a template for it contained in Regulation 2. You fill it in, complete it, have it commissioned and sent to us along with your application form and your other documents when you register. Alternatively, you can send it to audit at the ppra.org.za, and they will also send you a certificate. If you do it that way, you must submit that certificate with your application documents. Okay. Some information on deregistration, dormancy, ceasing to operate, selling as a going concern, or resigning as a director. This is going to be something that is quite new to the majority of your practitioners. And this is the fact that in terms of Section 54.9, you have to take certain steps to shut down your trust account, close down your business operations, or alternatively, have them transferred in the records of the PPRA to a new director before you can be deregistered with us from being a responsible person for that firm. Okay, so you cannot simply decide, okay, I've had enough of this business, I'm retiring, close your doors and leave. That is not permitted. Section 54(9) tells you what you have to do. The reason for that is because you may operate a trust account. You also will have a fidelity fund certificate, and there are certain things that must be done before you can simply close down and leave. The other reason for it is that in terms of the regulations, if you have a fidelity fund certificate, you are registered with us as a property practitioner, you are required to renew your fidelity fund certificate by the end of October of the previous year or the current year. And if you fail to do that, you will attract penalties. So if you leave and we don't know that you've left and you haven't wound up your firm, you are going to accumulate penalties for failing to renew your fidelity fund certificate. And in terms of the regulations, when you are leaving the industry, you must advise us in writing by the 31st of October of the previous year that you will not be operating the following year, so that you don't need a fidelity fund certificate. We will then deregister you, and you will not be invoiced with a fidelity fund certificate fee, and you will not be invoiced for penalties for failing to renew in time. Okay, so please note that if you closing, even if your firm becomes dormant and you're not operating, there's unfortunately nothing in the Act or regulations which says that if the firm is registered, has a trust account or whatever, and is not operating, that you are now excused from doing the financial statement audit or review, which the Act requires you to do for your business. You are not exempted from doing and submitting your trust audit report, etc. So the dormancy is not going to allow you to not comply with the provisions of the Act and regulations. If you cease to operate, or if you want to resign as a director, it's essential that you come to us and say, here is my resignation. If there is another director who is going to be taking over, or who is already existing as a director with the firm, that's fine. We simply need a document from the company, from the board, to state who the new director will be, or if there's no new director, that you are no longer a director, and we will then remove you. But the firm has to be compliant, and you have to advise us of that. In the case of selling a firm as a going concern, you need to ensure that the new director is on the SIPC documents, or member, or whichever it is, and that you send it to us, that you ask us then to deregister you as a director of that firm. Otherwise, you will remain responsible for compliance with that firm and with the PPRA. You also need to know that a director who deregisters a firm under Section 54(9) will be deregistered as an auctioneer, and his FFC will lapse. This is unless he is a director of another firm that is still registered with us and he continues to operate under that firm. All right. So again, that director cannot continue to operate in the industry unless he operates under a different firm, either as a director or as an employee. Similarly, an employee who leaves a firm will be deregistered with us and can only be re-registered when they have another application submitted to us with their letter of employment advising that they are now working for somebody else. If these things happen simultaneously, then we will not deregister you. We will simply do an employment change in our records, and you will then be able to be notified of that. We will look at that process in a moment. There is the information that you need to wind up your firm. It's Section 54(9) to 54(14), and you will be required to wind up and close your trust account if you have one, pay out all trust monies to the owners, deregister the firm with us, submit a winding up report on the trust account, which will come to our audit department, and once they have accepted it, you can then request the deregistration of the firm and yourself. Please note that if you have a non-compliant firm that is still open and you have not deregistered, you will not be able to get a Fidelity Fund certificate under any other firm. This is to stop any unscrupulous property practitioners from opening a firm, messing with the trust accounts, and then abandoning it and moving on and opening a new firm. No employee may be issued with an FFC if the firm and the director has not been issued with a valid FFC. Okay. You also need to know that all natural persons pay Fidelity Fund registration and renewal fees, but the firm does not do so. The firm pays an admin fee or administration fee. They do not pay for their FFC as such. In relation to FFCs, as I've indicated, FFCs are issued for 3 years. All employees who leave their employer must inform the authority in writing within 14 days of their change of employment and either register under another employer or be deregistered. And if they don't deregister themselves and they don't renew their FFC on time, they will be charged penalties. All property practitioners are advised to inform the PPRA before the 31st of October of the previous year if you are leaving the industry, as indicated before. Just to stop very briefly at fees and penalties, registration fees, FFC fees, and renewal fees are established by statute. All property practitioners who are registering with us for the first time pay a statutory levy to the Property Practitioners Fidelity Fund on first registration. In 2022, that was an amount of 400 Rand. It has escalated by CPI since then, but it's not a huge amount more than that. But that is only paid once, and that's towards the Fidelity Fund certificate, or the Fidelity Fund itself, the Property Practitioners Fidelity Fund. Penalties are also as set out in the regulations. They do escalate by inflation, as indicated. Fines for major contraventions are levied by inspectors. Sorry, I beg your pardon. For minor contraventions are levied by inspectors who use a compliance notice under section 24 to 26. If you want to go and have a look and see what compliance notices are and what inspectors can do, you can go and have a look at those sections. Major contraventions, however, are dealt with by a disciplinary process, which includes being notified. You are able to give a response. You then attend a hearing before an adjudicator, and a sanction can be issued if you are found guilty in the form of a reprimand, a fine, or in serious cases, the withdrawal of an FFC. The authority to reduce, increase, or amend a fine rests only with the adjudicator in disciplinary proceedings. So if you feel that the fine is too much or you have mitigating factors that you want taken into account, you can ask the legal department, instead of paying a fine notice, to please convene an adjudication, and you can appear and ask for leniency. You should bear in mind, however, that that adjudicator can increase your fine as well as decrease it. Contraventions or misconduct include non-compliance with provisions of the Code of Conduct or the Property Practitioners Act, and some of these are also criminal offences. Not all of them, but offences such as trust money irregularities, displaying of lapsed FFCs, failing to return money that you have received while operating without an FFC when asked to do so, or using the PPR name or logo without permission, are all criminal offences. There are others, but that's only some of them. Please note that you will find a schedule of fees and admin fees on the PPRA website. It's very important that you go to our website periodically in order to find notices on important events. If we have some kind of a system crash, you will find there that you will be told that that is the case, and that is why your applications may not be coming through to us. Please use an alternative address and we will give you one. Other things that are important are any notices in relation to what you can do or can't do. Also, all information on how you register with us is contained in the notices on the website. So please go ahead and look. And the chances are that you will receive the information you need much faster that way, because if you WhatsApp me or you email me, I usually have anything up to 500 emails a day. So there's absolutely no way that I can assist everybody promptly and as soon as I would like to. So the chances are that you will need to go and look at that in order to get your information straight away. All right, the registration process. The director of a property practitioner firm is required to register by submitting the following documents to the PPA or licensing and registrations department via the following email address. And I'm telling you the email address, ladies and gentlemen, because at the moment, this is how we are registering non-estate agents, non-attorney employees, and certain managing agents can also register via the portal, although it's not operating at the moment. So they are registering via their own email address, but you would certainly use the manual registrations at the ppra.org.za email address. And can I please ask that whenever you send anything in, you put your ID number in the top subject line so that we can identify it and assign it to the person who is dealing with your matter. You may submit an application. There may be something that you have omitted to add, and we may need to respond to you and say, please send us this or that. If you don't put your ID number in the top, we don't know who to give it to, who is already dealing with your matter. And as a result, you may then be allocated to somebody new, and somebody new then starts all over again with your process and doesn't know where your other documents are, spends time trying to locate them and find out who actually has them. So it's very important that you do that in order to avoid delays with your applications. What you need is your business property practitioner application form completed and signed by all the directors or members or trustees of the firm, company CC or trust documents or partners agreement showing details of these persons, a bank letter signed and stamped by the bank and confirming the details of a trust account held by the firm and stating that the account is held in terms of section 54(1) or 2 of Act 22 of 2019. Now that's very important because section 54 specifies that that trust account must be designated at the bank as an account held in terms of that provision. So if you send us a letter without that, we are going to send it back to you and say, please do it again, get the bank to do it properly. Alternatively, you may submit a letter of exemption from holding a trust account if you have been issued one by us, or an application in the form of the affidavit I mentioned, which will assist you to apply for such exemption. You also need to provide an auditor's letter, which I will deal with a little later. The auditor's letter is for those who have trust accounts and are required to audit their financials every year by the Act and are not exempted from that. So I'll explain that a bit later. But the auditor's letter simply confirms that he is an auditor for the company. A company resolution, if there are 2 or more directors, as per the company documents, confirming who may act as the principal of the firm, and that's the principal director. Okay, so in other words, the responsible director. A BE certificate, unless the firm is a sole proprietor or a partnership. Okay, you will know that there was some discussion on what a valid BE certificate was, and the decision after senior counsel was consulted was that a BE certificate must be valid as far as time and the issuing party is concerned, but it does not necessarily have to be compliant. That is the position at the moment. You also need to provide us with a SARS tax clearance, and that is required from all firms. And you're required to provide us with proof of payment of the administration fee for the firm registration process. We then move on to registration of persons. Sorry, I have auctioneers there. That's an oversight. I apologize. It should be for all property practitioners who are not estate agents, attorney employees, and those managing agents who are already registered with us. Here, your directors register themselves individually, submit all documents to the same email address which I gave you, and submit the ID document, the individual property practitioner's application form completed and signed, the E1 form applying for exemption from section 33, and proof of payment of your registration fee. Now, your E1 form allows for the exemption from Section 33, and it's necessary for the following reason. As I've indicated, nobody except estate agents has established requirements as to what the standards of training and education qualifications are that are needed to operate. That's not a problem. You don't need an exemption because that doesn't exist. However, there is a provision in Regulation 33 of the Act which says that no property practitioner can operate unless they have done a practical training course, which is accredited by us, and written your professional designation examination, which is your board exam. Now, obviously, there isn't a PDE for your industry presently. There also isn't a practical training course for your industry presently, which we have put out. So until such time as that has happened, you need to apply for exemption from Regulation 33 in that respect. And so that's why we ask you to submit that E1 form so that our auditors don't have a hissy fit when they come at the end of the year. So all that is a form. You say you apply for regulation for exemption from Regulation 33 insofar as is necessary. And the reason that you put is that there are not yet practical training or PDE examinations for your industry, which cannot be, so you are not able to comply with the Act in that regard. Employees follow a similar process. They also submit their individual property practitioner application form, the E1 form, which I've referred to, and a letter of employment, which must be signed by the director of the company and the employee themselves. And it must include the reference number of the firm and the director. And that is to ensure that we have your registration correct and that we in fact do register you under the correct firm. If the firm does not yet have that number, so in other words, if they've applied and you haven't yet received it, then you can put in your ID number and the ID number of the director and the full name of the firm that you want us to register you under in that document, that employment document. You will also be required to pay your registration fee, and that is done by submitting it to that email address. As far as fees are concerned, registration of a firm, as I said, is free. It only attracts the admin fee. It doesn't require an FFC fee. You will get a firm FFC as well as your own, and that is if you are the director. If you're an employee, you simply get your own. You will see the schedule of fees on our website, as well as the schedule for admin fees, and you can then make payment of those, consult it, and see which fee applies to you. You can also do the employment change, which I mentioned previously, and that requires submission of all the same documents as for an employee registration, right? So you submit all of that with your new form, your new letter from your new employer, and we will be able to transfer that for you if you have not yet been deregistered. Please be aware that this is quite important to take note of, because if you are employed under a firm and you don't tell us within the 14 days that you have left, the firm may advise us and may say, okay, this person is no longer employed by us. If we have not got an application to register you under another firm, we will have to deregister you because you are no longer employed by any registered property practitioner. So if you come to us a month or 2 months later and say, actually, I've got another job, I'm actually going to register under this one, you will have to do a re-registration instead of an employment change, and you will have to pay again for your registration. All right, your ID documents also needed so that we don't have people coming in and saying, I'm so-and-so, please register me, when in fact they aren't. And finally, we're just a short word on auditors. All registered directors need to see the audit manual on the website, please. There is a very nice audit manual which has been drawn up and placed on the website by our audit manager, who is Thomas Makupu, and it gives all the information on auditing, etc. So what's important for our purposes is that all firms have to submit their annual audit report in the format prescribed by the PPRA within 6 months of their financial year end. It must be submitted to the PPRA in good time, or penalties will accrue monthly. Okay. Please note that your audit report refers to your trust account. If you look at the template, you will see it is a trust audit report. So if you don't have a trust account and you're exempted, then you don't submit your audit report. All firms must also have their business accounts audited within the same period, but these need not be submitted. Okay, that's also in terms of the Act. So that's your financial statements, which need to be audited. However, I refer to Section 23 of the Act, which indicates that firms without a trust account and with a turnover of less than 2.5 million per annum do not need to have their financials audited. They can have them reviewed by an independent accountant. Okay, so that saves audit fees. So under those circumstances, you can do a review. Otherwise, you must do an audit of your business accounts. You don't submit them, but if an inspector comes to inspect your offices, he may ask for them, and then you will be charged if you don't have them. So that's a word about auditors, and that brings us to the end of the presentation. Thank you very much, and we'll have a look at questions now.
Thank you so much, Advocate. On the charts, we do not have questions. We have a hand from Elsa. Let me unmute so that we can start taking the questions. And colleagues that you've sent your email address on the chat, I've emailed you the presentation. Please check your inbox. Elsa, please unmute and ask your question to Advocate. Can you hear me? She's
Hi there.
struggling. I'm going. Okay. Let me go to Yena. Let me go to Yena. Please ask. I'll come back to Elsa. I think she's struggling to unmute.
Okay, perfect. So thank you. My name's Jenna Brocklebank. I just wanted to ask a few questions. I have put them on the Q&A portion of the presentation, but I'll ask them again. I just wanted to ask, when we submit the E1 exemption that's not for qualification to the Section 4 exemptions email address, must we attach the application form and all the submitting documents of that individual in that email? Or what are the steps? Because if we, as an individual, if we're asking for an exemption for them not being a South African citizen, for example, how are we going to, are we asking for, yeah, so is it with the manual registrations email address? How do we?
Okay, let me assist you. The only one that comes in with your application form is your E1 form, which refers to your Regulation 33 education exemption. Okay. All other exemptions go to exemptions, for Section 4 exemptions at the ppra.org.za. Okay.
Yes.
The reason for that is that exemption application then goes, it gets prepared, it gets checked for compliance, and it gets sent to an appointed exemptions committee, which is appointed by the CEO, and that committee has to consider it, advise you if there's any more information they want, advise you with the outcome, and advise you of any conditions attached to that exemption. Okay, so it's a completely separate process. And if, for example, you are a non-South African citizen, you don't have a work permit, you want to apply, and there are good reasons, you think you have good reasons why you can, then you need to provide that to us with the E1 form, specify what you want to be exempted from, specify why, and then attach to that only those documents which refer specifically to that exemption and which you want us to look at.
Okay, so then we'll do the E1 form with all supporting documents and motivations, and then would we, once we get, let's say, approval then do we send to manual registrations
That's correct.
that the application form with the approved exemption?
Yes, just in other words, your registration application form with all the registration documents. You don't send your exemption documents except the letter or the certificate.
Yes, perfect. Okay, thank you so much. I then also would just like to ask, so when we register, so is it correct that a director of a firm will register the firms, do the firm's application?
Yes,
when
all
we
the
do
directors
that,
need to. Please
yeah,
bear in mind in terms of the Act that all directors have to have a Fidelity Fund certificate. Okay?
yes.
So they will all register individually, and they will also send one application registration form in for the firm, which they will all sign.
And so do you register the director first and then the firm, or in one email you're doing the firm with all the directors' information if there's more than one?
Yes. What you need to do is you need to submit your firm application plus your director's applications all in the same email. Because if you send us one that says, okay, I'm applying to register the firm, and we see that the directors are not registered, we are going to say, you need the firm direction. Please send me the firm documents.
Right. And then, so does this also, thank you very much for that. Does this mean then we do not need to reserve a name that used to be a thing on the portal? You don't need to.
I'm just trying to remember. I think that the name reservation does apply, and we always did it for estate agents because there was a provision in the old Act which required us to do it. There is something similar in the new regulations, and if you send everything in and you apply for the name, we will look and see if there are any others on our records that are, because you can't operate under a name, a trading name that is confusingly similar or the same as another one. So if we see that you have the same one, then we will send it back to you and say, please tell us your new trading name. You can't trade under that name. It already exists.
Okay,
so you
perfect.
can't do a name reservation like you used to. It's a different system that we use.
Okay. And then, sorry, just two more questions, and then it's when you are registering an individual as a property practitioner, an employee, as a managing agent for a particular firm, can they be a timeshare employee for that same firm as well?
Yes, they can, but they have to have a Fidelity Fund certificate for both. So they must be registered under the firm in the industry of managing agent, and they must be registered under the firm in the industry of timeshare, and they must have a Fidelity Fund certificate for both.
Perfect, thank you. And my last question is, how long, more or less, in providing the PPRA with all the registration application forms, how long, more or less, does it take to get a firm or an individual registered?
Okay, in terms of the Act and regulations, we have a 30-day turnaround time. It allows us 30 days to provide you with your Fidelity Fund certificate after we have received a compliant application. So if your application is compliant, it should be, we try and get it to you before that, but there's no guarantees, and you should have it within 30 days. Okay. If your application is not compliant and we have to go back to you and say you haven't given us this or that, or you haven't signed this or that, or you haven't completed the form correctly, you forgot to tick this or that, then obviously those 30 days will only apply when your application becomes compliant.
Okay. And my last then question is, when we are submitting all these documents, is it better for the authority when it is all in one document, or would you like all the application form and its supporting documents separate so you can see it, or can it be in one document?
It doesn't really matter as long as it's in the same email.
Okay, perfect.
All right.
Thank you so much.
Okay. Thank you.
Thank you, Jenna. Advocate, I have a question from Nick. Hi, when registering a firm, can you include subsidiaries, or all subsidiaries need to be registered individually?
Okay, no, subsidiaries are not registered individually. They're registered under the main firm. But if the subsidiaries have a separate address and a separate branch where they actually operate from, then you need to advise us of them and we need to put them on our records. And bear in mind that under the regulations, we need to be able to issue you with a Fidelity Fund certificate for each of those offices, because the Fidelity Fund certificate for that office needs to be displayed in that office. Unless the subsidiary has exactly the same name, then it can use the main the holding company or the holding firm's FFC. So, for example, if we have it at the estate agents, you have Remax, and just as an example, should Remax Johannesburg have subsidiaries which are Remax Sandton, Remax Fourways, Remax Northcliffe, etc., then each of those must have their own Fidelity Fund certificates, but they are registered as branches of the original holding company or firm. If they, however, are on their own, then they will be registered separately under a completely new name. If they simply operate wherever they are as Remax Johannesburg, even though they operate in Fourways and they're from a different address, then they can use the Fidelity Fund certificate of the main office and display that in their offices.
Okay, thank you so much. Elsa, please unmute yourself. Let's try again because you were struggling earlier. Okay, I think she's still struggling. Please put your questions on the chat and I will read it out for Advocate. Let's go to Kari. Kari, please unmute.
Hi there. Morning. I'm trying to make sense of the order of things. I just want to confirm that I understand correctly, please. So is the first step that you have to go on and register your firm and your directors in the first email? And then once you get the confirmation back, and you then only register your individual agents, or is it all in one go?
You must have your directors and firm registered first. If you put employees, we will do the employees as well, as long as they've got everything that is required for their registration. And we will do them as soon as we've done the directors and the firm. There's nothing to stop you doing all three together. It will just happen in that fashion.
Okay. And then my second question is just on the trust exemption. So when you submit your firm application, one of the supporting documentation is your trust, your bank letter, from what I understood. Now, you said that the only exemption application that is submitted with your application is the E1 for education. But what do you then submit in lieu of your bank letter? Because there won't be a bank letter.
Okay, as I indicated in the slides, if you just go back and have a look, you'll see that it's specified. If you submit, if you want not to have a trust account, then you submit your affidavit.
Yeah.
And if you go back to the slide, I'm just going to go to the, that's not the E1 form, the registration process. Let me do it here. There it is under number 3, a bank letter signed and stamped by the bank, confirming the details of a trust account held by the firm and stating that the account is held in terms of Section 54.1 or 54.2 of Act 22 of 2019, or a letter of exemption from holding a trust account issued by the PPRA, or an application, in brackets affidavit, applying for such exemption.
Okay, so then the
exemptions. The one exemption is your E1 form, which is the education exemption or any other exemption. And the other one for a trust account is specifically the affidavit that's prescribed by the regulations.
All right. So everything goes together with your application to register?
Yes.
Okay. Then just another question is that in terms of the code of conduct, a while ago, in consultation with the PPRA, they asked us to submit a draft code of conduct for the time-sharing industry. I just want to get confirmation or clarity from you that we do the property condition report is obviously not applicable to the time-sharing industry, and that there will not be any penalties for not doing that together with your transaction.
Okay, the regulations are a little bit badly drafted when it comes to your mandatory disclosure form. in relation to the condition of the property. And the difficulty that we have is that it says all people who do selling and buying must do it, but it actually must also apply to renters, etc. And of course, the question then arises whether people who do short-term rentals or anything like that, or holiday rentals, are also included there. Our general consensus is that we do not expect your mandatory disclosure form in the format which is required here at this stage. If that changes, we will advise you, and we will provide you with a template that we can advertise and that we can give you to say, well, instead of doing a mandatory disclosure form, you can do something different. And that's if the board decides that something like that is required. At this stage, it isn't. But it's not a code of conduct issue. It's a provision on its own in the regulations. So you have to look at the regulation and see whether what you do makes that applicable to you or whether it doesn't, and make a decision from there as to whether you need to submit it. As far as the code of conduct is concerned, the code of conduct currently exists, and you will see that the first few provisions of the code of conduct in section 34 apply to all property practitioners. So those ones, everybody has to comply with. The majority of the code of conduct, however, applies only to estate agents. So the rest of it doesn't apply to you. And we are also given the responsibility to create codes of conduct for all industries, which we're in the process of doing. As you indicated, we did ask for that, and we've had submissions for various industries, which we're in the process of finalizing. So you will get a code of conduct for your particular industry in due course. For the moment, the existing code of conduct applies only in respect of the first few sections that apply to all property practitioners.
Thank you. And then my last question is just non-executive directors. Are they also required to do CPD, or are they exempt from it?
No, they don't have to. They don't have to get a Fidelity Fund certificate at all, so they're not required to do CPD.
Thank you.
Thank you so much, Carrie. I don't see hands. Let me go to the chats. We also don't have questions on the chat. And the Q&A, it's not opening. I've posted a message on that. Do you have comments, colleagues, before we close the webinar? If you remember a question, please email us. I will forward it to Advocate. We can still respond after the webinar. Anyone comments? Let me see. There's no comments. So Advocate, thank you so much for today's webinar. And I think what we took from today's webinar is that for exemptions, we know that we must use Section 4 exemptions email address and submit your E1 form. And we know that if it's equivalence exemption, it's for education under Regulation 33. And for audit, we know Section 54, that's where you'll be exempted for audit. And Advocate also presented on your winding up of the firm, which is your Section 54, 9 to 14. We must also look at that, colleagues. And also, let's visit our PPRA website. That's where we're going to find most of the information that is going to assist us. If you decide to leave the industry, you remember to send us a letter within 14 days if you stop trading. And also our renewals is going to close on the 31st of October, and fees are on our website. And remember, these fees are legislated. And also to avoid the fines, whether the fines are coming from inspections, penalties, or adjudication processes, find out more, what you are being fined for. You can request a breakdown from our finance. It will show all the statements so that you know what you are being fined for. And she also touched on the BEE. We know that it has to be valid. And we really appreciate colleagues for today. And also, I think it's important to know that when you're submitting your auditor's report, if you have a turnover of less than 2.5 million, you would not need auditors, but an accountant can assist. And we know that all directors must have FFCs. And our turnaround time in the registration department, it's 30 days. But remember, your document must be compliant. If you're submitting documents that are not compliant, it might delay the process. And when you send us an email that you're not getting joy, you find that there's documents missing. But also our registrations department, they will also contact you and let you know what is it that you need to submit. Maybe, for example, your ID is not there, or your SARS documents, if they're not there. Please do not forget, remember Advocate mentioned that when you are emailing your manual registrations PPRA email, put your ID number at the top so that we can know who's working with your application. Colleagues, I do appreciate for joining the webinar. We're going to download the recorder. We're going to put it on our YouTube, PPRA TV. Please follow us on all our social media, LinkedIn, Twitter, Instagram, and Facebook, and visit our website. That's where we post our notices every day and communication on the new announcements that you're going to find. I've sent the presentation also to Lee. Lee, you will help me to share with colleagues on your side. We're going to have the next webinar that will include all the categories next week, Friday, 13th of September from 10 to 12. We will share the link and the invite on our social media. Kerry, we do appreciate the communication, and let's continue from now on to ensure that all timeshare and industry and others wanting to join in the future, that they can be registered. Advocate, I appreciate your time. We appreciate the presentation. It was very informative. And the registration colleagues who joined today, thank you so much. And we can get to work and service you, timeshare members. Thank you so much. Bye-bye.
Thank you very much, everybody. Bye-bye.
Bye.
Goodbye.